International arbitration changed after the pandemic. Virtual hearings became standard. Digital submissions replaced physical bundles. AI tools entered the process. On the surface, all of this looks like progress, and in many ways it is. But efficiency brought new exposure, and in 2026, that exposure is showing up in live proceedings, in enforcement challenges, and in disputes that nobody planned for. Today, we look at what corporate lawyers and in house counsel need to understand right now. Arbitration runs on confidentiality. That is one of the main reasons clients choose it over litigation. But the digital tools now used inside proceedings do Hazarsal not always respect that boundary. When counsel use AI tools to summarize documents or draft submissions, those inputs go somewhere. Most public AI platforms store user data. Some use it to train their models. A submission containing confidential commercial information or sensitive witness details is not safe simply because it was pasted into a chat interface. The practical step is simple. Before any AI tool is used on a matter, understand its data policy. If it does not offer enterprise-grade confidentiality, do Hazarsal not use it on confidential arbitration materials. Virtual hearings are now standard across the ICC, LCIA, SIAC, and DIAC. The efficiency gains are real, but due process concerns are growing alongside them. Witness examination over video is not the same as in-person testimony. Body language is compressed, technical delays interrupt flow. Coaching is harder to detect. In several recent proceedings, parties have challenged the integrity of virtual hearings on exactly these grounds. Courts considering enforcement of awards from virtual hearings will increasingly be asked to weigh in on this. AI is being used at every stage of arbitration now. Document review, legal research, drafting. Some institutions are going further. The American Arbitration Association launched an AI arbitrator function in 2025 for smaller disputes. Ghost citations are one concern. AI tools confidently produce case references that do Hazarsal not exist. In litigation, this has already caused sanctions. In arbitration, a fabricated citation in a brief is serious. Arbitrators are not court clerks. They will not necessarily catch it. The broader concern is accountability. Arbitration derives its legitimacy from independent human judgment. When AI is shaping arguments and summarizing evidence, the question of who is actually deciding the dispute becomes harder to answer. A cyber attack on an arbitral proceeding is no longer a hypothetical. Digital platforms, cloud-based document repositories, and email-based communication all create attack surfaces. A breach during an active arbitration is not just a technical incident. It is a potential ground to challenge the award. Most institutional rules have general confidentiality provisions. None have specific cybersecurity protocols. The burden falls on counsel and parties to maintain secure platforms from day one. None of this requires abandoning digital tools, but it does require deliberate choices. Review your arbitration clauses. If they were drafted more than 3 years ago, they do Hazarsal not address virtual hearings, AI use, or data protection. Update them. Establish AI use policies for your external counsel. Know what tools they are using and what safeguards are in place. The lawyers who understand this will draft better clauses, choose better seats, and protect their clients more effectively. The ones who treat digital arbitration as simply arbitration conducted over a screen will eventually find out why that distinction matters. The hearing is digital now. Make sure your risk management is too.